Idaho is a very unique state in this union. Like a handful of our states have decided that firing squad is the right choice if there's no lethal injection drugs to carry out execution. So this is happening, folks. This is happening in Idaho as of like a month and a half from now. It is going to be a viable form of execution in Idaho, the firing squad. And the reason this is so critical is that today, Bryan Kohberger learned he's up against 4 first-degree murder charges in Idaho. They carry with them the death penalty. And if they can't find the drugs, it's the firing squad. So that just gets very real very, very fast. And maybe it's for that reason things went a little weird today in the arraignment. I'm not exactly sure, but I've got 2 people who know a lot more about Idaho law than I do. I want to bring in Richard Blok. He's an Idaho criminal defense attorney, and also Jessica Bublitz. You both are, perfect guests today because I was shaking my head wondering, this doesn't look right. This doesn't look like, the kind of arraignment I've heard before. I've seen plenty of arraignments where a defendant doesn't say anything or is incompetent or doesn't have an attorney beside him or her, and the judge will enter a plea. But I've never seen somebody look so engaged verbally and mentally, and then stop talking. So, Richard Blok, I'll begin with you. What happened there?
I don't know. It's certainly an unusual one. I don't think there can be any strategy that I could figure out from this that makes any sense to me. I've heard some commenters say something about him trying to work up an incompetency defense of some sort, but that seems really strange. This is not a good way to do it. I think more than likely, Ann Taylor's got a really difficult client who's going to be a problem, and she's going to have a lot of trouble controlling him and getting him to do the things he needs to do to present a good defense.
Well, I get incompetence because I've seen people drooling at defense table and acting irrationally. But Jessica, this man was not that. He was nodding along at exactly the appropriate times. He was answering clearly and definitively, yes and no, and yes, I do. He was perfectly competent because, as we all know, competence is, do you understand the charges against you, and can you aid your attorney in your defense? And that man was, to a T, the perfect example of competence. So again, that threw me into a bit of a pickle, trying to figure out why all of a sudden Ann stood up immediately, Jessica. They had orchestrated this. She stood up immediately to answer for him. He didn't even try to answer. She didn't even have to look to wonder why he wasn't answering. Did that give you a clue?
Well, Ashleigh, there are a lot of attorneys in Idaho who actually believe that if you stand silent when it comes to a grand jury indictment, it gives you more of an advantage when it comes to challenging that grand jury indictment for various legal reasons. There is a little bit of support in that for Idaho law. I don't personally think that it would make a difference, but my impression is that this is likely just Ann Taylor's method, par for the course for her, when she has a client in the situation where they're going to be potentially challenging a grand jury indictment. She stands silent as opposed to entering that not guilty plea.
So, Richard, jump in there. What's to challenge? I mean, a grand jury is a grand jury. Some people say ham sandwich. I don't believe that's true. I think that you should give grand jurors a little more credibility than that. It's certainly a one-sided process. But what is to challenge in a grand jury indictment?
So there's a number of things you can challenge in a grand jury indictment, including if any of the jurors should have been disqualified. And that's often one of your stronger arguments because the defense isn't involved in picking jurors. There are quite a few other things that you can challenge in a grand jury indictment as well. The fairness of the process, if they were not presented with the mitigating information as well as the information that would tend to make the grand jury want to indict. So this may be part of the process for Ms. Taylor or not, I don't know. But there's quite a few things with the grand jury indictment that you can try and challenge.
Okay, so Jessica, I'm going to give you the last 20 seconds here, and it is a hard 20, but is that kind of one of those good luck with that?
They're going to challenge absolutely everything that comes their way, and they don't have a copy of the grand jury transcript yet, so they're going to look through that when that comes in, and it'll probably take a couple of weeks. And then when it comes in, they're going to look at the process and see whether or not it was all done correctly, and whether or not the standards were met, as counsel here also indicated, as far as the legal requirements. If there is something they can challenge, I have no doubt they will. They probably won't be successful, but there will be several things coming along in this case in that manner. So this won't be the last time.
Thank you for watching. Go to newsnationnow.com to find NewsNation on your television provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.